the contract just wasn't written as well as it could have been. So part of this job that we do as lawyers is like thinking of every possible situation that could happen.
Wow, that's interesting. There could be some creative people out there, right?
Yeah.
We have a studio full of them. Welcome to episode 10 of Business Talk with Eric Chau. Today, we're going to explore the ins and outs of buying or selling a business with a couple superstar attorneys from Lowenstein Sandler, a premier law firm with over 350 attorneys and over $500 million in revenue in 2022, placing them as the top 99 of the AmLaw top 200 in the U.S. Today, we're joined by Associate Rasmeet Chahil and partner Nick Samedi, where they will unveil the top 3 major mistakes that could kill your M&A transaction and 6 must-dos before you sign your letter of intent. Nick and Rasmeet, welcome to the show.
Thank you. We're excited to be here.
Excited to be here.
Amazing. Well, this is I think it's a pretty important episode for 3 reasons. Number 1, this is officially our 10th episode of Business Talk with Eric Chau. Hopefully we get to triple digit one day, right? Second, this is the first time in our show history where we actually have 2 guests on the show. So congratulations on making that history.
Thank you.
And number 3, I think this is probably the most important, is that for some of our audience who are business owners, small business owners, entrepreneurs, and I think at one point in their journey, they're gonna consider either buying or selling their business. And I'm happy that we have a couple experts in the audience today, and as a guest, and that can give some valuable insight on merger and acquisition, and also commercial transaction. And but without further ado, welcome to the show, and please tell us who you are and what's the reason that you decide to practice in your respective area.
Sure. I'm Rasmeet Chahil. I'm an associate in the White Collar Criminal Defense Group at Lowenstein Sandler. I also practice commercial litigation and bankruptcy litigation. I decided to come to Lowenstein because the firm does a lot of important work. We work with big clients. We do exciting work. The firm is located in New Jersey. We also have an office in New York. So it's easy to kind of move. And DC. We have also an office, Utah and Palo Alto. But being based in New Jersey and being able to work across New York and New Jersey both was also a big draw. You know, our office is in nice suburbia, and I have a 7-minute drive to work, but I can also travel into the city when I need to. So those were kind of the things that drew me to Lowenstein.
Yeah, you know, as I gave in the intro earlier, I mean, Lowenstein Sandler is one of the largest commercial law firm in the country. I think it's in the top 100 in terms of revenue. So welcome to the show. And I think it's appropriate that you go first. We're both Michigan alumni.
Yes.
No offense, Nick. No offense. But so.
Hi, everyone. Nick Samedi, partner at Lowenstein. I'm in the transaction advisory group. I primarily do mergers and acquisitions. On the buy side, I typically represent private equity funds. So I come in after the capital is pooled and everything is aggregated and they're ready to deploy. So I'll work with the private equity funds from the time they pick a target until the time they deploy the capital, they purchase the target and everything in between. After that, I'll work with them until they eventually sell off the platform. So all the bolt-on acquisitions, all the work that goes along with that. I also have a part of my practice that's kind of corporate consulting. So helping people with their organizational documents, helping people also get funding, and making sure that they're kind of abiding by the letter of the law when it comes to their different industries. So awesome. it's a good mix of work.
And what fascinates you the most about your practice area?
So before I went to law school, I was a financial consultant, and I touched M&A a lot from that business consulting and valuation side. I thought it was very interesting and very fascinating, so I made a decision back then to go to law school, and it's been a lot of fun.
And I'm glad you mentioned you brought that up because I think with a lot of small businesses that we dealt with, one of the challenge or struggle is to really figure out the true valuation of your company. And as you know, there's always owner's bias, right? They always think it's higher than what it really is, and until you really dig deeper behind the scene, right?
I believe that's one of the topics that we're going to discuss, is really making sure that you understand the market and you have a very strong team around you. I think as you go through the process, that your team will help you understand your value and if it's the right time for you to go out to the market. I think one of the most important things to do is really be patient as a business owner. You kind of make sure your house is in order, understand what you want out of the deal, and make sure you find the right buyer to help you make that vision come true.
Awesome, thank you. Well, let's get into the conversation. The topic that we're going to discuss today is our 3 major mistakes that could kill your M&A transaction. And without further ado, we'll dive into the first one, which is
making sure you have all the ownership interests properly documented, making sure you know who the owners are, and if you've promised anybody equity stake in the company, making sure that's all properly documented. That's
a long mistake. Let's just sum up what Rasmeet said. Improper ownership structure of your company.
Yes.
So.
And part of my practice is coming in kind of when things are going wrong and helping out our transactional partners, like Nick and some of the others at the firm. So I had a client come to us. He had a business in the pharmaceutical industry. He was trying to sell the business. He had offered ownership in the company to one of his friends, but they had done this very informally over like text messages.
Like a handshake deal.
Yeah, it wasn't ever like properly documented.
But through text.
Through text, yeah.
Okay.
And so he was trying to sell the company. He had a buyer lined up. Everything seemed to be going well. And then the other guy comes in, goes to the buyer and says, "Hey, I actually own a part of this company and I haven't approved this transaction. So you can't sell this company without me." The buyer kind of got spooked at that point. The client came to us and said, "Can you help us fix this?" Turns out the friend had also offered our client interest in his businesses. And so there was kind of a lot of informal things going on that had never really been put down on paper. We ended up settling where our client had 100% equity in his business. The other person had 100% equity in his businesses. Nobody had interest in each other's businesses. So we kind of figured that out and documented it. And that allowed our client to then go forward, continue marketing the company, and find a new buyer. Because the first one had walked away. He was like, "I'm not getting involved with this mess." So ideally, it's something that you deal with ahead of time before you even get to the point where it becomes a problem.
Becomes a litigation, right?
Exactly.
I think this, I mean, it seems like a common sense, right? In terms of, try not to go to court, try not to get into litigation. And I think part of, your job is more of the risk mitigation. And that's why we're having this conversation today, to help businesses prepare themselves so they don't have to go to court or they don't even have to worry about settling, right? Because we have done the work ahead of time. And there's just the saying where the best way to do something is to do it right the first time.
Correct. And, the issue here is that a lot of times, as Rasmeet was saying, it happens very informally. So you could have a very good year and you promise someone a bonus or a piece of the profits, or you say something in passing that gives them the idea that they're going to be a true owner, an equity holder in the company. And it only comes back around when you decide that you want to sell the company. A buyer, when he's looking at a seller, is going to do a lot of due diligence and a deep dive into your history and everything that you've promised people, right? And at the end of the day, most of the times they want to be the one sole owner of the business. So who actually has a legal claim to part of the equity is a huge part of what they're trying to verify. So again, as Rasmeet said, that buyer walked away. And we often see that when if you can't assure them that they're going to be the one owner of the company after they pay you whatever the purchase price is, that they will walk away. Again, it's a way to really quickly and easily destroy trust in a process that will take a couple of months, and that there has to be a lot of trust between the parties, especially since both parties are going to be spending a lot of time with each other and a lot of money with their advisors, making sure that the business is operating well and they're getting what they think they're buying, they're selling what they think they're selling. So this is like a very fundamental issue.
Do you have a quick story, entertaining story you can share with us without naming anyone?
Yeah, so also in the pharmaceutical space, and a different client than with Rasmeet, very similar, where it was a very informal kind of handshake deal where he promised an employee, their number one star employee, that the buyer wanted to go with the business, a percentage of the business when he sold it. And it was never documented. It was just like, yeah, you're going to get 10%. You're going to get 10%. And when the time came, he didn't get his 10%. So it was a staggered sign and closing. So a situation where you signed the deal.
But did it delay the process? Just the fact he came to the table and say,
so he
claim
came to the
10% of
table,
company.
Unfortunately, after the deal was signed, but before it closed. It's very common for you sign the deal, you need certain regulatory approvals or third-party approvals.
Mm-hmm.
The employee found out about it during that time.
Okay.
So after the money was already committed, they signed and they said, we're going to close once, the government says okay and our biggest customer says okay. The key employee was approached for an employment agreement to go with the buyer. And that's when he said, where's my 10%? Nobody told me about this.
Wow.
The original deal that was struck between the seller and the buyer did not contemplate this. And ultimately, the seller was not willing to make the employee whole. So not only did the buyer walk away, the seller now had a huge issue with his number one employee. So the business did not recover, and it ended up becoming a huge issue for something that we could have tried to work out before we found a buyer.
Okay. Well, we don't want, probably don't want to get into the specific of the type of advice that you're giving. Obviously, this show is not about that. This is for general educational purpose. But what would you say to address that issue, right? An employee claiming a share of the company, right, out of the blue. Anything the owners can prepare ahead of time in terms of maybe documenting exactly if any employees would have any ownership or planning to, like, and any thoughts on that?
I think an easy way to do this is to have either a written or well-known bonus structure that has to do with just compensation as opposed to equity. So some people get around it that way by just making sure everybody knows and their program is compensation only, whether it's a bonus.
Like an RSU or something like that.
Well, so we try to stay away from RSUs because those go on the capitalization table, and it's essentially an ownership, a restricted ownership unit. So we try to stay away from those and just say you're going to get a flat bonus.
Okay.
You may get a bonus that can be a flat bonus, or it can be based on some metric, whether it's revenue that you bring in or EBITDA or something like that. But we try to make it very clear it's not an ownership stake.
Okay, I'll shut my mouth. Okay, no more suggestions from Eric Chau. That's wonderful. Thank you for sharing those stories. Diving into the major mistake number 2 that could kill your M&A transaction, and when it comes to, I think the evaluation of a company. Really, besides its people, its intellectual property has a big impact on the valuation of the firm, right? So what is the major mistake number 2?
So major mistake number 2 is not properly documenting the ownership of your intellectual property. So how we typically see this happen is that you have employees or third parties who are working together or working on the IP, sometimes the main product or asset of the business, and that IP is not properly assigned beforehand to the company. So the way this typically happens is that a person example is, again, in the pharmaceutical space, where there are a number of employees who were hired that are going to be working on drug X. And in their employment documents, they sign offer letters and they sign employment agreements. There's typically a section called an invention assignment agreement, which essentially says all of the work that you're doing for the company, belongs to the company. So all that IP that you're creating, any iterations, any derivations, everything belongs to the company. It's in that packet that you typically give and that you get, they sign and they get back.
But not all companies have them.
Not all companies have them, and not all companies keep records of them being signed, and you'll keep them in the drawer.
Okay.
So when the time comes to sell, the buyer comes in, they say, we love your product X, please show us your IP documents. The number 1, 2, 3 scientists don't have any documentation saying that the IP that they're creating belongs to the company.
That's red flag. Or hesitation for the buyer.
Correct, because if, again, similar to the cap table, this is very fundamental to what they're buying. And if they don't know that they're going to own this IP asset free and clear, all of a sudden the transaction does not look as profitable to them. It's not as attractive.
Mm-hmm. Anything to add, Rasmeet?
Yeah, and if the seller is going to retain any of the IP assets, you want to be really clear about that. I had a case where the seller had a couple stores that they were trying to get the inventory sold off, and so they retained a license to use certain trademarks for a specified period of time. And I think the contract said something like they have to be used in substantially the same manner as they were before the sale. What they did was they started using that brand name with other brand names and kind of like diluted the brand. We represented the buyer in the situation, right? And they were not happy about the situation. Unfortunately, the contract just wasn't written as well as it could have been. So part of this job that we do as lawyers is like thinking of every possible situation that could happen and coming up with really, really specific contract terms to address that, especially important with IP and trademarks.
Wow, that's interesting. There could be some creative people out there, right?
Yeah.
We have a studio full of them. All right. Wow, amazing story here. All right, jumping to major mistake number 3 that could kill your M&A transaction. I think most business owners, right, are very deep into what I call the 3 Ps, right? The purpose, the people, and the product. They know those kind of in the back of their hands. And just from a personal experience working with over 300 small businesses in my career, one trend that I notice is small business owners don't usually keep a very good record on financial related stuff, financial record keeping. Not the number one thing on their mind. Let's just say that, okay? Because they're so busy creating the next best thing. So can you share with us what is the major mistake number 3 that could kill your M&A transaction?
So financial record keeping and just record keeping in general for certain items we'll talk about that a buyer will be really interested in. So again, when you look at it from a buyer's perspective, in addition to buying an asset that they think will be profitable, and many times they're buying an income stream, a revenue stream.
Yes.
So we'll talk about it a little bit later as far as how they verify that, but being able to provide good records, good inventory, and just show proper record keeping, not only builds trust between you and the buyer, it really helps them verify and solidify a price for your business. If they have to go back, redo all of your records, they do not have confidence in your accounting and your finance team, it makes it very hard for them to really stick to a price, right? They may give you a range, and it becomes a little bit more difficult for you as the seller to really have a good sense of what you're going to be getting for your business. Mm-hmm. So again, while it may not be the primary function, you have to remember you're essentially selling sometimes an asset, but also a revenue stream. Mm-hmm. The more that you can really solidify that and prove it, it's going to be much better for you in the long term.
Mm-hmm. Okay.
Yeah, I think the company also needs to have a specific document retention policy that specifies what types of documents you need to be keeping and how long you need to be keeping them for. So in some industries, there's very specific rules on that. So if you have
Is that a good rule of thumb, like 5 years, 7 years?
It all depends on
70 years.
Well, if you're keeping stuff from 70 years, you're going to have boxes and boxes. You're going to have to buy a huge storage facility, and that's not going to be good for the business either. So it's kind of a trade-off, and it depends on the type of industry that you're in. If you're in some sort of healthcare industry, there's certain rules around how long you have to keep those sorts of records. But just have something documented and make sure all of the employees know about the policy, so you don't have one-off employees who are, throwing documents away. You don't want that, especially if you're in litigation or if you're in some sort of dispute that might turn into litigation. As soon as there's a possibility of litigation, a company has an obligation to retain all documents related to that. So even if you have a retention policy that says 5 years, if you're in litigation, you need to keep those documents until the litigation concludes. So you have to suspend the policy, the normal policy with regard to those specific documents. And again, it's something that should be well known about at the company, so that kind of everybody's on the same page and everybody's maintaining the same records.
That's cool. Okay.
And
Well,
Eric, I see where you were going. Typically, the policy will say 1 year or delete immediately, 1 year, 3, 5, 7. And then longer periods, as Rasmeet said, depending on the industry. I think sometimes healthcare is like 9 to 10 years, depending on the exact records. But it'll be very clear, and your team and your employees will know when they should be kind of deleting documents.
And when it comes to the financial record keeping, right? This is the part that you don't really want to be too creative with it, right? You want to stick to what the industry standard, whatever the accounting system they go by, because as you said, income stream is important for some buyers, right? How it's being looked at, what standard is using. I think that's extremely important. So I guess it would be helpful, right, to speak with someone, a legal counsel, right, or CPA, right, who understand the industry that you're working in, and figure out what is the standard.
Agree.
Right?
Yeah, definitely.
Okay. Wow. Man, we only have like 20 minutes left, guys. We have a lot to cover. All right, we want to do some what they call rapid fire type thing for the next topic that we have. Now that we have gone through the 3 major mistakes that could kill an M&A deal, right? We're gonna dive into a second topic, which is the 6 months due. What's that? 6 months due before signing a LOI, letter of intent. Okay, so the first one is assemble a transaction team. So, how about we'll have Rasmeet get started, or either one. This one.
So I can do this one. So I think the important takeaway here is that an M&A attorney and M&A accountant is very different than your standard record keeping and standard commercial business attorney.
Okay.
Right? There's, as you were mentioning before, there's a certain industry, there's a certain market, there's certain standards that they will know that will help you kind of work through the deal process. Every deal has a cadence and there's a timing around it, and kind of having the information that you need when you need it, knowing the industry standard, knowing the industry players really helps to move the process along. It also gives you this air of legitimacy when you're talking to buyers, which we'll get to a little bit later, right? So your average accountant that does your financial reporting is not going to know those things, and when it comes time to deliver financial models, financial metrics that the buyer is going to want, it pays and will really help the process to have somebody who knows what they're doing, who's done it before.
Who specialize in the M&A space.
Correct.
Not just your general accountant, that does your bookkeeping.
Correct. They're going to be instrumental to the process,
Yeah.
but they won't be doing a lot of the modeling and a lot of the back and forth with the buy side accountants.
I see. Okay, wonderful. Anything to add on the first must do, assembling a transaction team?
No, I think we can move on to the next topic.
Wow, this is rapid fire. All right. Second one, it's a corporate cleanup, and that's usually done through the attorney.
Correct. So again, just looking back at what we just mentioned, to the extent that there's issues with the cap table, employee issues, IP issues, maybe some employment claims, you can get all of those in order before you select a buyer, and you'll have a story to tell them about why there was an issue, how you cleaned it up, and make sure that there's no risk to them going forward. The issues really arise when it comes up in the buyer diligence and you don't have a good story or a good way to show that you were involved, you mitigated their risk, and it's not an issue going forward.
So would you say it's like, I mean, I hate to say this, but like, everyone's got some dirty laundry, right? I mean, every business probably has some dirty laundry. Is that let's say from a seller side, right? Is it best to just disclose it upfront if there's any like hidden information
So-
that you want to keep from everybody, really? But
So yes, it's definitely better to disclose.
Yeah.
And working with your counsel, you'll figure out when is the best time in the process to disclose it
Okay.
and who to disclose it to.
okay,
So
like if I have
disclose-
like a like a I don't know, a personal note or a company note to ABC person or ABC lending company, right?
Yeah. So let's use that example. So
Yeah.
if it wasn't disclosed in your financials, which sometimes it is, sometimes it's not, it should be, having a business to business conversation of what it is, why it is, how it's going to get paid, whether it's personally or through deal funds, and having a plan in place that you offer to the buyer is much better than them seeing all of a sudden a note got delivered in the data room. The attorneys read it and they come up with their own narrative of what's going on, and they get to the buyer first. So again, these are all things that can be cleaned up beforehand. You come up with the story and you show how it's no risk to the buyer and it's being mitigated, and that way that there's no issue. The real problems occur when it doesn't go through that process.
Awesome. Thank you for clarifying. No more dirty laundry, guys. Okay. The third must do, quality of earning, QOE.
Okay, so quality of earnings is that deep dive financial analysis that the buyer's accountants will do on your business to verify your income stream. So typically the way that these deals are priced is that they're going to look at the income stream, something called EBITDA, earnings before interest, taxes, depreciation, and amortization, and they're going to apply a standard industry multiple to it. So you make $10, it's a $10 multiple. Your interest, it's a 10 multiple. Your business is worth $100.
And it varies by industry.
It'll vary by industry.
It could
And
vary by a lot.
It can vary by a lot, and sometimes, depending on how bad the buyer wants the deal, they may increase it, right? So instead of maybe the industry standard is 10,
or the growth rate.
correct, and they'll make it 11, 12 to make it more attractive, and that's how they'll justify the purchase price to their investors, and that's how that part of the deal will get done. What's important about the quality of earnings is that there will be deductions to it. So whether it's different employment expenses, whether you're not keeping up with your CapEx and they need to add more CapEx, and there's ways that they will find to decrease your EBITDA
From the buyer side.
from the buyer side. So what's important is on the sell side to make sure you do that analysis first, working with M&A accountants. You figure out where the pain points might be, and you figure out how to have a story to say why what you're doing is right. Whether it's CapEx, employment expense, IT expense, that your numbers are right. They shouldn't be taking deductions, which will decrease your purchase price based on the multiple. This does two things. One, again, legitimacy and trust. It shows that you know what you're doing. You're sending the right message to the buyer. But also for the seller, it gives you a better sense of what your actual purchase price may be. It takes away that owner's bias. And it also helps you figure out if there's things that you should be doing, whether it's decreasing your interest expense, your employee expense over time, increasing your IT expense, to try to get your EBITDA as attractive as possible without any deductions. So it helps on multiple levels.
Oh, I see. Wow. Okay. So even on the sell side, you have a lot of preparation you got to do.
And you don't have to
before
do
you
it,
even
but
go into a discussion, really.
Yeah, we find that the people who do it, the businesses who do it, have a better sense of what they're getting into.
Yeah.
And there's typically a better result with less owner's bias.
Okay.
So they're ready for what the numbers are going to be, what the range is going to be. And there's less, of that feeling when they actually get the numbers.
Okay. All right. Sounds good. And just, I guess, going back to the second and the third point, doing the corporate cleanup and also the quality of earnings analysis, like at what revenue point of a company you think is really worth it to have those analysis done? Because if you're making like 100,000 in your business, you probably don't need to do that, I don't think. But for a multi-million-dollar revenue generating business, and I just don't know what price point is really the most appropriate.
We've seen this as low as, I would say, revenue in the 10 million-ish range.
10,
But really, it not only does it depend on the revenue, but it also depends on who you're selling to,
Okay.
right? Because you have to make sure that you as the seller are meeting the expectations of your potential buyer.
Correct.
So as you continue to go up that list, if you're really looking at targeting yourself towards private equity,
yeah.
in many
Or
cases, it's going to
venture cap.
venture. It's going to be something that they're looking for. Now, again, that's not going to stop them from doing their own quality of earning analysis, but again, it's going to prepare you for what they're going to be looking for and for what your ranges of values will be. And also,
Well
if there's
said.
issues, it comes to the surface, and when the buyer uncovers it, you have that story ready to go.
Great. Okay. Point number 4, man. We need more time, guys. Point number 4, selection of banker.
So I'm happy to take this one. So the banker is super important because they are who helps you find the buyer, right? They will know the market, they'll know the industry, they'll know the pain points, and they're going to help you make the company as attractive as possible. So picking your banker is very important for that reason. And you typically will find your banker. You can find the industry bankers, we'll call them, through your accountants, through trade shows, through word of mouth, and through your attorneys. And it's really important to find somebody that you trust, that you get along with, because you're going to be spending a lot of time going through your business and going through your history and working with them and the buyer. So it's important to get along with them to kind of be on the same page, but also for them to have that background knowledge and industry experience. Again, the banker is the one who has the book, who's going to help you market the company, right? So finding somebody that's in the industry, that's well known, is going to help you find the best buyer.
And I would think that the attorneys that you work with, the M&A attorneys the client works with, probably have some contacts in various industries, right?
Definitely.
Yeah.
Attorneys can be a great source. Your M&A attorney will be a great source of finding that banker, and they'll also help you through the process, right? There's going to be an engagement letter that talks about different fees that the banker will receive, as well as a number of items that will be negotiated. And again, that's another reason why it's important to have an M&A attorney, to make sure that you're paying the market rate, and that the expenses, like the expense reimbursement and everything, is kind of the standard suite of expenses.
Okay, cool. Okay. Must do number 5, pre-transaction internal diligence.
So again, this is kind of going back to some of the topics.
That's a mouthful.
Yeah, it's
internal
again,
diligence.
going back to some of the
Know yourself.
Yes, that's exactly it. If we wanted to end it there, that's the
Move on
really
to
the phrase.
two.
So you just have to make sure that any issues that may come up in buyer diligence, that you've touched it first. You understand where the pain points are, and when the buyer comes and says, "Hey, we see that you have this pending in front of the EEOC. What is the employee alleging? Or we see that you have this harassment claim. How was it? How did this happen? What policies were broken? How did you remediate it?" That you're able to go and you have an answer and you have a story and you're able to explain it, because on the buyer side, they're looking for the least amount of risk possible. So you have to, again, keep that aura of trust, keep that relationship working, and make sure you have answers to all of those questions.
Got it. So it's okay to make mistakes as long as you understand why you made those mistakes and how you fix them.
Exactly.
Right. And it's good to have good policies in place. So in Nick's example, if you didn't even have a sexual harassment policy, right, that's a huge red flag. You want to show that you have really good internal policies and procedures in place, that employees have channels to make complaints, for example, and that if there are internal issues, they're being taken very seriously by management and they're being investigated. My firm does a lot of internal investigations of things ranging from employee misconduct all the way to misconduct.
White-collar crime.
Right. Yeah, right. Exactly. Fraud, financial mismanagement. But you don't always need an attorney to do those types of things, right? If you have a really good HR manager, somebody ideally who's trained in doing those types of investigations, that's a good way to manage it. But a lot of times when you're a small business, you're not really focusing on that as much. You're focusing on running your business, right? And sometimes I see small businesses that don't have anybody even with an HR role. So that's something that's really important to think about and make sure you have the right internal policies in place.
Okay, great. Off to number 6, must do. Confidential information memorandum.
So confidential information memorandum is also called a SIM. It's the document where the banker is going to review your company, go through that internal due diligence, and they're going to review the market, and they're going to place you in basically a sales document of where you are in the market. They're going to justify your earnings, and they're going to talk about how you're the best business in the world and why the buyer should buy you. So working through that process and making sure that this is a story that you're comfortable with, that makes sense, is very important. And it's also important to make sure that it includes your plans for you and the management team. So where we see an issue here is where a seller is not sure what they want to do, and they kind of leave it up to chance, leave it up to the bank, or leave it up to other people to decide, and that comes through in the SIM, that gets to the buyer, and it creates a mismatch expectations. So an easy example is if you are the seller and you want to continue with the business, you're just looking for a liquidity event, it's important for the SIM to be structured that way. If you're looking to get out and to walk away and to never be seen again, it's important that you don't sell yourself in the document, right? That it's just your management team. The management team's not going, make sure that they're not a highlight of the SIM. So really just thinking through as a seller what you want and making sure that's appropriately reflected is what's very important here.
Cool. Man, that rapid fire in 10 minutes. Man, that's a lot to do for business owners that are looking to sell, right? And I think majority of the audience here is probably it's gonna be on the sell side, right? For now, because they're still building their empire, and but these are amazing points. And we got another bonus question for the audience. This is actually a kind of a personal question that I am curious about. As Warren Buffett says, right? I would rather pay a fair price for a wonderful business than paying a wonderful price for a fair business. And obviously, everybody wants the best price, either on the sell side or the buy side. So any advice you would give, to both buyer or seller, right, during this type of negotiation? Maybe one of you can touch on the buy side, one of you can touch on the sell side.
Yeah, I can talk about the sell side. I think the most important thing is to make sure your house is in order before you go out and start marketing. And as we've talked about, it's really important to have the right professionals in place. So get your attorneys involved early, get the right bankers. I've seen companies operate for a long time without having any counsel, and I've seen them try to draft their own contracts, right? And then they get down the road.
Legal Zoom, huh?
Let me know next time you need help, Eric.
Okay.
But then we get to that.
No, I don't use them.
We get to that phase, right? And then they have all these contracts that aren't written very well, and it's like they could have solved the problem if they had just hired counsel like a long time ago. And again, making sure right policies are in place, that the employees know what they are, and that overall the company is operating, with integrity, and that it has a good reputation in the marketplace. Because you don't want to be trying to sell a company where it looks like things aren't really being managed well, and there's going to be a lot of liability down the road, right? Like no buyer wants that.
Okay. Next.
On the buy side, I would say it's important to do your due diligence. There's a lot of times, especially in the last few years, where there's a lot of hot assets and buyers are paying multiples that may not be justified by EBITDA. They're not necessarily doing very thorough Q of E's, and later on they realize that there's issues. I think it's really important to verify the asset that you're buying, verify the operating income and the EBITDA, and move forward from there. You're not always going to win, but it's, as you mentioned, it's important to understand what you're getting, and it just takes time to go through those steps.
Yeah.
Buyer's remorse is really, really tough because there's going to be limited ways for you to kind of get your money back when there's an issue.
Mm-hmm. Do you see a lot of that happening, buyer's remorse?
Yes.
Yeah.
And in fact, we're dealing with a couple of cases now where the business diligence may not have been as solid as they thought or they hoped, and they kind of went off of the words of the seller and the management team. And a lot of times it goes back to really, really poor record keeping, but we really want the business, so we're going to pay the industry multiple. And they find out the financial information was even worse than they thought, or the inventory was worse than they thought, or that there was issue with customers, and they decided that they're going to leave now that the business was sold. and
You
they
just lost the most important asset, right?
correct.
People.
So it's important to, even though we're in a time where deals are moving a little bit faster, people are spending capital, can be spending capital more quickly. It's important to make sure you do your pre-deal due diligence.
All right, all right. Wow, we're almost there. Almost there. We only have like 2 minutes left. So, one last question that I think would be beneficial for the audience is, what's one advice you would give to small business owners or entrepreneurs that are looking to, let's say, looking to sell a company in the next 45 years. So what, besides, I guess, the 6 to-dos that we touched on, or any other particular advice that would be beneficial on the sell side?
You want me? I can go first.
Yeah, sure.
So be patient. I think a lot of people jump into the process. They don't have an idea of what they want or what they're looking to get out of the deal. And as you go through the deal, it becomes much more difficult to put that out there, right? Again, if you're an owner who wants to walk away, it's important that from the very beginning, the buyer knows that, because they might be buying you and your management team. And if you're not coming, it could kill the deal. Also, being patient and making sure that you find the right buyer that does right by your customers, that's going to do right by your employees, is very important. So it may not be the best price, but you have to make sure that you're considering all of the factors, and that, the vision that you're looking for, the buyer is going to be working to fulfill that.
Okay.
Yeah, I think you just always have to be thinking towards the future, not just running your business day to day, but again, like 5 years down the road, what do you want it to look like? And have you managed and created your business in a way where somebody external is looking at it and thinking like, hey, this is a great asset? And that, again, goes to other things, the internal policies, making sure there's not tons of litigation against the company that's going to be raising red flags that you're doing something wrong. And just thinking about it in a way that's not just, okay, I need to run this business day to day, but make it sustainable for the long run.
Wow. Thank you. Wow. Thank you so much. Rasmeet and Nick, you have, I feel like I've been drinking out of a fire hose, legal fire hose for the past 45 minutes, but appreciate you guys taking the time to come out, and hopefully the audience will get tons of value. And most importantly, I think most importantly is have an action item that they can implement right away, regardless whether they plan to sell now or 45 years from now. I think there's something they can do that can make a difference for the business. So thank you very much, and we'll see you in the next show.
Thank you for having us.
Thank you.